case briefs, and so much more. LSData's got what you're looking for.
A case once sailed on turbulent legal waters when Neil W. Swinton managed to sell a termite-infested house without attracting any charges for non-disclosure of the defect. In this 1942 case, Swinton v. Whitinsville Savings Bank, heard by the Massachusetts Supreme Judicial Court, the principles of buyer's risk was put to a rigorous test. In 1938, Swinton, the defendant, had sold a house to the plaintiff, whose identity remains undisclosed. Unbeknownst to the plaintiff, an unseen threat lingered in the woodwork of their new home. By 1940, the new homeowner discovered a severe termite infestation eating away at the property. Costs for repairs and termite treatment subsequently soared into significant figures. This led the plaintiff to sue the defendant, accusing Swinton of intentionally concealing the termite problem, thus committing a fraudulent act. However, turning the tables on the accusation, the defense argued there were no false statements or misrepresentations made by Swinton during the sale. The transaction had been a standard business deal and no special duties, such as fiduciary obligations, had been tied to it. The main contention here revolved around the defendant's purported concealment of the termite infestation. The dice had been cast and the court's judgment fell in favor of the defendant, Swinton. The Massachusetts Supreme Judicial Court dismissed the plaintiff's case, upholding the notion that the seller held no obligation to disclose a hidden termite conundrum. As such, the precedent of non-liability for non-disclosure was affirmed, leaving the plaintiff's case sinking without legal validation.
Case briefs, and so much more. LSData's got what you're looking for. Visit LSD.law, elevate your mind. Leave the stress of climb.